Okay, let's unpack this. Imagine the highest stakes, your finances, your reputation, even, your relationship with your children. And the person across from you is simply, well, they're lying. How do you defend your truth when it's under fire like that? Today, we're diving deep into a strategic guide for navigating these really high-conflict family law proceedings, where countering falsehoods with precision with evidence it's absolutely crucial.
That's exactly right. Our mission for this deep dive is really to understand that battlefield of he said, she said in family court. We'll explore how you can effectively prove truth using methodical, rigorously documented evidence. Because in court, well, it really comes down to the balance of probabilities, which story is more likely true.
Right. And to guide us through this tricky terrain, we'll explore the top 10 most damaging lies you might face. We've got to categorize them into, say, financial deception, custodial warfare, and narrative manipulation. And we'll also look at a powerful 4-pillar defense framework designed to, hopefully, turn the tide. Okay, now let's address something critical first. We all hear about lying under oath, right? Perjury. But our sources, they actually confirm criminal charges for perjury in family court are incredibly rare, like almost never happens. So what is the actual penalty for lying when, the DA probably isn't getting involved?
Yeah, that's what we call the perjury paradox. It's interesting. While criminal charges are, like you said, very rare, the immediate and frankly devastating consequence for the person lying is the complete destruction of their credibility with the judge. Think about it. If a judge believes you're a liar, they start viewing your entire testimony with suspicion. And that can be absolutely fatal to your case. So the strategic goal isn't really about getting criminal charges filed. It's about proving the lie so thoroughly, so completely that the liar's credibility just evaporates. Their whole case just becomes untenable. The key takeaway here is really, your entire defense hinges on systematically dismantling their narrative.
Okay, understood. So the court's focus stays squarely on this case, the family case, not some separate criminal thing. Right, let's move into the first big area then, the financial fog of war, where money matters become, a prime target for deception.
Oh, absolutely. Financial deception is, it's a cornerstone of so many high conflict divorce cases. It directly impacts everything: property division, child support, spousal support. And these lies, they're rarely isolated incidents. They often form this kind of interconnected web. You expose just one lie, and sometimes the entire deceptive financial structure just collapses.
Okay, so let's start with lie number 1. The phantom paycheck. I don't earn that much. This has got to be one of the most common financial lies, right? Especially for people who are self-employed or work mostly in cash. What kind of tactics do they use?
Yeah, you see it all the time. Tactics include things like underreporting business income, maybe deferring bonuses or commissions until after the divorce is final. Exaggerating expenses is a big one. Or just plain working under the table. We've even seen really extreme cases of fabricated sudden income drops. I mean, like a client falsely claiming his father died, forcing him to quit his job, all just to avoid paying child support. The motivation, it's pretty simple. Minimize their financial obligations, pay less.
Wow. Okay, so how do you compel the truth then? When they're actively trying to hide it, what do you do?
Well, the counteroffensive has to be methodical. First, formal discovery is absolutely crucial. And this isn't just asking nicely. It's a legal compulsion for them to produce documents, bank statements, tax returns, business records, you name it. And signing these under penalty of perjury, that's a critical tipping point. It puts real teeth into the request. Then you might need forensic accounting. These are like financial detectives, really skilled at uncovering hidden income streams, comparing things to industry benchmarks. Lifestyle analysis is also really powerful. If someone claims they only make $60,000 a year, but they're clearly spending $120,000, well, that's compelling circumstantial evidence right there. And finally, depositions. This is your chance to lock the dishonest party into their story under oath. So the core insight for the phantom paycheck is basically legally force transparency and then expose the inconsistencies between what they claim and what reality shows.
That's a really clear roadmap. Okay, moving to lie number 2, the shell game. This asset doesn't exist. This is active concealment, right?
Yeah.
Basically fraud. Where do people typically try to hide assets that don't have obvious public paper trails?
Right. These are the hidden treasures, so to speak. You see secret bank or investment accounts, sometimes funds transferred to friends or family members they trust. Purchasing hard-to-trace assets is another one. Think art, collectibles, precious metals, or even, increasingly, cryptocurrency. Private safe deposit boxes are also pretty common hiding places. The motivation here is blatant. Illegally shield assets from being divided fairly in the divorce.
So how do you go about uncovering these hidden treasures? It sounds like detective work.
It really is. It requires meticulous effort. Meticulous document review is absolutely key. You're looking for red flags in tax returns, maybe unexplained interest or dividends, unexplained large withdrawals from bank statements. Sometimes loan applications are revealing because people are often more truthful about their assets when they want something, like a loan. In more complex situations, you might bring in private investigators who specialize in asset searches. They can be invaluable. And don't forget, witnesses and subpoenas, people they confided in or institutions holding records can be compelled to testify or produce those records. And here's something really striking. Judges often have the discretion to award the entire value of a concealed asset to the innocent spouse, plus sanctions on top of that. So the takeaway is, hidden assets usually leave some kind of digital or paper footprint, and aggressive legal tools combined with expert eyes can definitely uncover them.
Wow, that's a huge consequence. Awarding the entire asset that can really shift the whole financial picture. Okay, let's talk about lie number 3, the false bargain. It's not worth very much. So if they can't hide an asset, they try to lowball its value. Which assets are most susceptible to this kind of undervaluation?
Exactly. This happens a lot with assets that don't have a readily available market price. Think family businesses, unique personal property like art or jewelry, intellectual property, sometimes business franchises too. Anything where the value isn't immediately obvious. The goal is simple. Reduce the financial payout to the other spouse during the property settlement. Make their share smaller by making the total pot seem smaller.
Right. So what's the absolute non-negotiable step to counter this lowball tactic? What do you have to do?
It's straightforward. Independent valuation is non-negotiable, period. Never, ever just accept the other party's valuation, especially if it seems low. You must hire your own certified experts. That means forensic accountants or business valuation experts for businesses, certified appraisers for real estate, specialized appraisers for things like art or jewelry. Their neutral expert reports carry significant weight with the court. It cuts through the bias. So the core insight here is pretty clear. Objective third-party valuation is basically your shield against deliberate undervaluation.
Makes perfect sense. Get your own expert. Okay, and finally, for the financial deception category, lie number 4, the mountain of debt. I owe everyone money.
This sounds like creating phantom liabilities to reduce the net worth. What's the most common tactic you see here? Yeah, the classic move is the sudden repayment of a large, usually undocumented loan, supposedly owed to a close friend or family member, mom, dad, best friend. Often, this is just a fraudulent transfer. It's designed to move marital funds into friendly hands, maybe with the expectation they'll get it back later after the dust settles. The motivation is clear. Reduce the net value of the marital estate on paper, which then lowers the amount the other spouse is entitled to receive.
Okay, so how do you dismantle this debt deception? How do you prove it's fake?
First, you demand documentation. For any claimed debt, especially these supposed personal loans, you need to see the paperwork. Where's the promissory note? Records of the initial money transfer? Is there any payment history? The absence of all this is a major red flag. Real loans usually have documentation. Then, you trace the funds. You can subpoena the bank records of the person who supposedly received the loan repayment, see where that money really went. Did they immediately withdraw it as cash? Or maybe transfer it right back to the lying spouse a week later? That's strong evidence of a fraudulent scheme. The takeaway is really, question every undocumented debt, especially new ones, and always follow the money trail to expose these sham transactions.
That covers the financial battlefield pretty thoroughly. It's a lot. Now, let's transition to what is arguably the most destructive theater of conflict, custodial warfare. I mean, these lies weaponize children, which is just, it's truly heartbreaking. What's the court's guiding principle here? What's the surprising risk for the person doing the lying?
Yeah, it's incredibly tough. The court's guiding principle always, always, always is the best interests of the child. That's the standard. And the risk for the liar. It is significant, surprisingly so sometimes. When a parent gets caught fabricating serious allegations, especially things like abuse, it can backfire spectacularly. The court might actually conclude that this malicious deception itself proves that the lying parent is unfit. It can lead to the court questioning their judgment, their stability, and potentially even reversing custody in favor of the parent who is falsely accused.
Wow, a really powerful potential reversal. Okay, let's tackle lie number 5 then, which our sources describe as a kind of silver bullet lie, false allegations of child abuse, neglect, or substance abuse. What forms does this usually take, and what are the motivations behind such a devastating lie?
This is, without doubt, the most dangerous type of lie in family court. It can range from complete fabrications, just making things up out of whole cloth, to gross exaggerations of minor incidents, often with very suspicious timing, like right before a key hearing. Forms include false claims of physical abuse, emotional abuse, sexual abuse, neglect like not feeding the kids properly, or serious substance abuse problems. Motivations can be varied and complex. Sometimes it's purely tactical, aiming for an emergency restraining order to get immediate leverage and maybe temporary sole custody. Other times it's driven by revenge, pure desperation, intense fear, or even underlying psychological issues, like certain personality disorders where reality gets distorted.
This sounds like an absolute immediate crisis for the person accused. What's the right way to respond? What's the immediate disciplined reaction?
Absolutely, it's a crisis, and it requires a very specific crisis response protocol. Number one, and this is hard, stay calm, do not retaliate. Emotional outbursts just play into their hands, they look bad. Second, hire an experienced attorney immediately. This is not a DIY situation, it's an emergency. Third, comply strictly with all temporary orders, no matter how unfair they feel at the time. Don't give them ammunition. Fourth, cooperate fully with investigators like Child Protective Services, CPS. Be transparent, be honest. You might want your attorney present for interviews. Fifth, start building a comprehensive evidentiary defense. You need to overwhelm the false claim with contradictory evidence, texts, emails, photos, videos showing normal interactions, school records, medical records, statements from neutral witnesses like teachers or doctors. And finally, request objective third-party evaluations. Things like forensic psychological evaluations, comprehensive child custody evaluations, or the appointment of a guardian ad litem that's an attorney or professional appointed specifically to represent the child's best interests. These neutral experts can provide unbiased recommendations to the court. The core insight is really immediate, calm, strategic, and heavily evidence-driven action is absolutely paramount when you're facing false abuse allegations.
That's incredibly vital advice. A clear plan for a nightmare scenario. Okay, moving on to line number 6. The character assassination. They are an unfit, uninvolved parent. Yeah. This sounds more like a war of narrative, right? Painting a generally negative picture with broad, often vague claims. What are some common examples?
Exactly. These are often subjective claims, harder to pin down sometimes. Things like, oh, he was never involved with their schooling, or she has no real bond with the youngest, or just broad portrayals of the other parent as being generally angry, unstable, selfish, maybe prioritizing work over the kids. The motivation is usually to create a negative narrative, a convincing story for the court, to justify awarding them sole custody, or at least primary physical custody.
Okay, given how vague these accusations can be, how do you effectively counter them with objective facts? How do you fight that narrative?
You fight narrative with facts. You build what we call a parent portfolio. This means first, you document everything meticulously. Keep a detailed calendar or log of your parenting time. Save all communications related to the children, texts, emails, messages. Then you gather third-party validation. This is huge. School records, report cards, attendance, notes from teachers, letters, or even testimony from coaches, pediatricians, therapists, daycare providers, anyone neutral who sees your parenting. And crucially, show, don't just tell. Don't just say you're involved, prove it with tangible evidence. Photos and videos of you with the kids, school projects you helped with, documented proof you took them to doctor's appointments. The key takeaway here is simple. Combat those broad, subjective claims with meticulous, objective documentation and corroboration from neutral third parties.
That makes sense. Focus on concrete proof again. Now, line number 7, the alienation tactic. They are turning the child against me. This describes that really destructive psychological manipulation, parental alienation. How does this lie typically manifest in court?
Yeah, parental alienation is incredibly damaging. And ironically, the lie often manifests as projection, meaning the parent who is actually doing the alienating, bad-mouthing the other parent, interfering with contact, sharing inappropriate adult information with the child, accuses the targeted parent of doing exactly that. The motivation is often to justify limiting or even eliminating the targeted parent's contact. They try to convince the court that reducing contact is somehow in the child's best interest because, supposedly, the targeted parent is the source of all the comfort or distress.
Right. And it's often said that judges, they might struggle to diagnose this complex dynamic without specialized help. It can be subtle. So what's key to combating alienation? Are there common pitfalls in identifying it?
Yes, it's definitely nuanced, and judges aren't therapists. That's why expert evaluation is key. A comprehensive custody evaluation or a psychological evaluation performed by professionals specifically trained in alienation dynamics is often crucial. A common pitfall for courts is mistaking a child's genuine fear or anger, perhaps based on actual experiences, for alienation or vice versa, wrongly dismissing real alienation as just typical divorce conflict. That expert insight is vital to distinguish. You also absolutely need to demonstrate your own positive co-parenting efforts. Meticulously document every reasonable child-focused communication attempt you make. Create a powerful contrast between your behavior and the alienators, and importantly, frame the argument around the child's rights. It's not just about your right to see your child, but the child's fundamental right to have a healthy, loving relationship with both fit parents. The core insight really is specialized expert evaluation combined with a demonstrable, documented commitment to positive co-parenting are vital tools to expose and counter parental alienation.
Okay, we've moved from the financial battles to protecting children. And now we enter this final theater of conflict, the narrative war. Our sources call this the credibility contagion effect. What does that actually mean for someone in court? How did that work?
It means exactly what it sounds like. A proven lie about something fundamental, like the nature of the relationship itself, immediately calls the liar's credibility into question on everything else. Finances, parenting abilities, other specific claims they've made, it all gets tainted. Once a judge believes you've lied convincingly about one major thing, they start suspecting everything else you say. That doubt, that suspicion, it infects their entire case. So yes, a proven lie about, say, domestic violence could absolutely infect their credibility when they start talking about financial assets too.
That's a really significant blow to someone's entire case then. Okay, let's look at lie number 8, the false victim. Fabricated allegations of domestic violence. Yeah. This is often described as a tactical weapon to get immediate control. What's the anatomy of this lie, and what's its primary goal usually?
Yeah. These claims can be truly devastating. They can range from complete fabrications, just making up incidents that never happened, to dramatic exaggerations of normal marital arguments, twisting them into something sinister. The primary goal often is tactical, to obtain an ex parte temporary restraining order or protective order. Ex parte means they get it initially without you even being present in court to defend yourself. This can lead to your immediate removal from the family home and often an immediate order of no contact with your children. It instantly establishes a powerful narrative of victimhood for the accuser and puts the accused on the defensive.
Right, that immediate impact is huge. How do you respond swiftly, and again, using evidence, to such a high-stakes accusation?
It's very similar to the response for false child abuse allegations. You adhere strictly to that crisis protocol we discussed, remain calm, obey the temporary order completely, get an experienced attorney immediately. Then the crucial step is to challenge it vigorously at the formal hearing. This is usually scheduled fairly quickly, and it's your critical opportunity to present your defense. You need to present contradictory evidence. This could be things like amicable text messages or emails exchanged around the time of the alleged incident, alibis, location data from your phone, or work records proving you weren't there, witness testimony from friends, family, or neighbors who saw something different. And your attorney's skilled cross-examination of the accuser is absolutely vital to highlight inconsistencies, exaggerations, or outright fabrications in their story. The takeaway is really swift adherence to the legal process, combined with overwhelming contradictory evidence presented at the formal hearing, are crucial to defeating false domestic violence claims.
Okay, moving to lie number 9, the moral high ground. Distorting infidelity and abandonment. A lot of people still assume that proving their spouse is somehow a bad person, maybe they cheated, will help their case, even in no-fault divorce states. How do people lie about infidelity specifically?
Right, the moral outrage angle. They might fabricate an affair entirely, or more commonly, they might misrepresent the timeline, claiming an affair began before the couple separated, trying to paint the other person as the reason for the marriage ending. Sometimes it's pure projection. They lie to conceal their own infidelity while loudly accusing their spouse. Now, while most no-fault divorce systems make the reason for the marital breakdown legally irrelevant for the divorce itself, the motivation here is often just to tarnish the other person's character, maybe hoping to subconsciously influence the judge's overall view of them. Though it is worth noting, there's a legal concept called marital waste, or dissipation of marital assets. If someone spent significant marital funds on an affair like buying expensive gifts, trips, apartments for a lover that can legally impact the asset division, the money itself is the issue there.
Okay, so unless there's a claim of that kind of marital waste, is the timeline of an affair even legally relevant in a typical no-fault system? Does it matter legally when it started?
Not directly for granting the divorce itself, no. But like I said, it can still influence perceptions or be used to muddy the waters. So the counteroffensive is twofold. First, establish a clear timeline for the separation. Use digital evidence texts, emails, social media posts announcing the split. Use financial records showing separate households. Make the date of separation undeniable. And second, focus relentlessly on legal relevance. Consistently argue, through your attorney, that in a no-fault state, the cause of the marital breakdown is simply not the issue before the court, unless there are specific claims like dissipation of assets being made. This helps keep the court focused on the actual legal facts that matter for division and support. The court insight is, while moral arguments about infidelity rarely hold legal weight in no-fault cases, establishing clear timelines and maintaining a focus on legal relevance can prevent character attacks from derailing the process.
Right. Keep it focused on what legally matters. Okay, and finally, lie number 10, the global indictment, the kitchen sink of character assassination. This sounds like just a relentless barrage of smaller, often maybe unverifiable negative claims. What's the goal of just throwing enough mud, as they say?
Yeah, that's exactly it. The goal isn't necessarily to prove any single specific allegation convincingly. It's more about creating this pervasive negative atmosphere around the other person. The liar hopes that by overwhelming the court and the other party with a flood of accusations, maybe about poor financial decisions in the past, questionable friends, old mistakes, personality flaws, that some of that mud will stick. They hope it colors the judge's overall perception and judgment when it comes time to decide the really important issues, like finances and custody, even if the specific mudslinging isn't directly relevant.
Wow, that sounds absolutely exhausting and potentially overwhelming to deal with. How do you avoid getting dragged down into responding to every single little accusation?
It is exhausting, and that's often the point to wear you down. It's a trap. So the first rule is, do not engage every single lie. You can't. It will bankrupt you emotionally and financially, and it just makes you look defensive. Instead, you have to work with your attorney to identify and isolate the material lies. Triage the allegations. Focus only on those accusations that are actually relevant to your fitness as a parent or to the financial issues at hand. Ignore the petty stuff. Then, you methodically disprove those material lies with concrete, solid proof. Concentrate your energy and resources on demolishing these few key falsehoods. Once you've successfully disproven those key lies, you can then expose the pattern to the court. You argue, essentially, Your Honor, we've shown this person lied about X, Y, and Z, which were material. This establishes a clear pattern of dishonesty. Therefore, you should view all these other, smaller, unsubstantiated claims coming from this now unreliable source with extreme skepticism. This actually turns the liar's own kitchen sink strategy against them. The key takeaway: focus your firepower on disproving the important lies, then use that success to establish a pattern of deception that discredits their entire barrage.
Okay, so we've really broken down the common lies, categorized them. Now let's shift gears slightly and talk strategy from a broader perspective. Beyond just simple greed or revenge, what truly drives someone to lie so aggressively, so persistently in court like this?
It's often a really complex mix of factors. Yes, sometimes it is calculated advantage, trying to get a better financial deal or win custody. Revenge certainly plays a role for some. Intense fear can also be a driver, fear of losing their children, fear of financial ruin. But it's also crucial, and our sources emphasize this, to recognize the potential role of personality disorders. Individuals with conditions like narcissistic personality disorder, borderline personality disorder, or antisocial personality disorder often exhibit patterns of manipulation. They might have a lack of empathy, a distorted view of reality. This can make them prone to fabricating detailed narratives, sometimes quite convincingly, often without apparent remorse or understanding of the damage they're causing. Understanding that possibility can be important for strategizing.
That's a really important dimension. Okay, let's revisit that perjury paradox we talked about earlier, but now from the judge's perspective. You said criminal charges are rare, but our sources outline some really powerful consequences a judge can impose within the family court case itself for documented deception. What are these case-altering penalties?
Right. Even without involving the criminal system, judges have broad tools to punish dishonesty when it's proven within the case. These can include attorney's fees and sanctions, ordering the lying party to pay some or all of the other side's legal fees and costs incurred because of the lie. That can be substantial. Adverse rulings on custody. This is huge. If false allegations about abuse or fitness are proven malicious, it can lead to the liar losing custody or being restricted to supervised visitation. For finances, there's the possibility of unequal division of assets. We mentioned this with hidden assets. A judge might award the entirety of a concealed asset to the honest spouse as a consequence, but honestly, perhaps the most profound and damaging consequence is the simple loss of credibility. Once a judge decides you've willfully lied to them, their trust in you is gone. It's almost impossible to regain. And that means they may disregard, or at least heavily discount, pretty much everything else you say or argue for the rest of the case. It cripples your ability to effectively advocate for yourself on any issue.
That loss of trust sounds like the ultimate penalty within the case itself. Okay, so bringing it all together, for anyone listening who might be facing this or worried about it, what are the absolute core pillars for building an airtight defense? What does everyone need to understand?
An effective defense against this kind of attack really rests on 4 unwavering pillars. Pillar 1, maintain your own credibility at all costs. This is paramount. You must be scrupulously honest, completely consistent, totally transparent in your own disclosures and testimony. Your unwavering commitment to truth becomes your ultimate weapon against their lies. Don't give them any ammunition. Pillar 2. Become a master archivist. I can't stress this enough. In he said, she said battles, the person with the best documentation often wins. This means proactive, almost obsessive record keeping. Save everything. Texts, emails, social media messages, keep journals or logs, gather financial records, school reports, medical documents. This detailed archive becomes your arsenal of proof.
Okay, honesty and documentation. What are the final 2 pillars needed to effectively counter this kind of deception?
Pillar 3, weaponize the legal process. Don't just react. Be proactive. Aggressively and strategically use the tools the legal system gives you. That means formal discovery requests to demand documents and answers under oath. It means depositions to lock the other party into their testimony. It means subpoenas to compel records and testimony from reluctant third parties like banks or employers. These aren't just procedures, they are tools to actively compel truth. And finally, Pillar 4, deploy objective experts. Neutral, qualified third-party experts are invaluable for cutting through the emotional he said, she said. Whether it's a forensic accountant for financial issues, a certified appraiser for asset values, or a custody evaluator or psychologist for parenting disputes, these experts provide the objective analysis the court needs and respects. Their unbiased testimony carries enormous weight.
This whole deep dive has really shown that navigating family court against someone who is fundamentally dishonest is, well, it's immensely challenging, no doubt, but it's absolutely winnable with the right strategy. It really seems to be about abandoning those purely emotional responses and adopting a disciplined, methodical, evidence-driven approach instead.
Exactly. That sums it up perfectly. The ultimate strategy is to build a case so thoroughly supported by documented facts, verifiable evidence, and independently corroborated information that the opponent's lies simply collapse under their own weight. They become unbelievable in the face of your proof. Remember, the most effective response to lies is not necessarily to argue louder, but simply to prove better. Let the evidence speak for itself.
That's a powerful closing thought. Considering the heavy emphasis throughout this on documentation, on objective experts, this deep dive really highlights just how critical preparation and keeping a clear head are in any high-stakes conflict, not just court. Kind of makes you wonder, doesn't it? What seemingly minor detail in your own life, a text message, an email, a receipt, might someday become a crucial piece of evidence in some unforeseen future conflict? Something to think about.